permission to make out of this. Make an out of list mention, my lord. Matter pertains to public interest litigation, my lord, wherein, my lord, we had alleged that the state government was diverting funds. Matter came up on 17th August. Your lordship had posted the matter 4 weeks, and in the online portal, it shows it should have come today, my lord. Not been
So
listed.
that is a tentative this thing. What is to be done in your case?
Any dates may be given, my lord, because there is an urgency insofar as
What is the urgency?
the urgency is, my lord, the 7,300 crores was allotted, my lord, a particular party to which a tender was given. Now they are, my lord, diverting the funds from the HMDA to the state government. They're taking it away. It's the specific allegation in the PIL. This pertains to the outer ring road.
Monday.
Please, Raj.
Please, Your Lordship.
Kindly permit me, Miller, out of Miller. The matter
Please,
is
Your
that
Lordship.
pertaining to Miller interstate transfer Miller from the
Huh?
state. The matter is Miller pertaining to interstate transfer.
Fresh filing.
Yes. Already Miller, the honorable court direct to notice before admission Miller, the honorable court Miller direct
So what do you want?
the interstate transfers Miller from the state of Andhra Pradesh to state of Telangana Miller.
No, correct. Then
Sir,
what do you want?
The showing as the kindly posted me on Monday.
Why?
The urgency Miller, the petitioners working as the teachers Miller. If Telangana government filed one pending Miller, the AP government also accepted the even consent.
What? You are arguing the matter on merits, and when we will ask questions, you will turn the page.
The online Miller, the show
Is for what purpose you want listing of the case number one, and what is the urgency? What purpose you want?
the honorable
It
court
is to be heard finally,
Yes.
right? And then make an application for urgent hearing. It can't be listed. Yes.
the online Miller showing
Tomorrow.
sorry Miller.
Your Lordship,
I insisting.
Yes.
This writ petition has been admitted, Your Lordship. Says this writ petition has been admitted by Your Lordships, and they had to post along with the connected matter. On verification, Lordships, there are no connected matters in this, Your Lordships. The urgency is that, Your Lordships.
So what is the petition has been admitted? You want final hearing today, certified copy to be delivered.
Not today, Your Lordships. Not today. It may be taken
Some other day. So then application for early hearing. Yes.
Please, Your Lordship.
Sorry Miller.
Writ appeal, Your Lordships.
Writ appeal of the year 2023.
Final hearing we cannot direct. Yes.
Writ appeal of the year 2023. Your Lordships have admitted this appeal on 28th of August.
Whatever.
Now the suspension petition has not been disposed of and is still pending. Now the
You want consideration.
Now, the Enforcement Directorate on 5th of September has issued a note of demand more than 100 crores from all the appellants. From 15 days from 5th September. 15 days from 5th September.
1 minute, Mr.
15 days from 5th September, the Enforcement Directorate has now sought demand to the tune of more than 100 crores from the writ appellants. Please, Your Lordships.
Milordship,
Yes, this is what we want, that you wanted consideration of IA and you told urgency. This is what we are asking. There nobody is telling. They are arguing on merits. Madam, please.
I need admit.
Huh? Neat admission and everything is over now.
Milordship, every year conducted that is one yearly once Milordship. But now conducted is second phase Milordship. But my petitioner is
What is the urgency, madam?
tomorrow is the last day of station Milordship. Kindly have this panel lunch Milordship.
What do you want? You want striking down of rule? You are treated as non-local candidate.
Milordship, my can.
Achha, lunch. You supply a copy to Mr. Rao. Lunch motion. Yes.
Apologize, Mr. Lordship. The matter was on Monday, my lord, but Monday is a holiday.
Oh, sorry. It will be Tuesday then.
Your Lordship, so
Tuesday.
Tuesday,
Tuesday.
Wednesday, my lord, instead of Tuesday. If your Lordship so please.
Nothing happens, Mr. Though no irretrievable, this is a public interest litigation. No irretrievable prejudice. It's not that government of Telangana will run away with the money and go to South Pole where we will not be able to trace the government. This all, I mean, settling personal scores and all that. This all. This is the, we understand. We have also been there. We have defended so many public interest litigations. Our clients tell why it has been filed. So I've been a lawyer who has always appeared for respondents in a public interest litigation. So other side of the story I have always known. So we know what is it like. My lord, 20th September, right? 20th. You want it on, no, not 20th. You want it on a Wednesday, right?
Yes, 20th.
So Wednesday is then
20th.
not 20th, where 20th is Tuesday, 21st will be Wednesday, 21st.
Obliged.
My lord, my is a case of attachment. My lord, may I make a mention, my lord?
Fresh matter, what?
My lord, my case is of attachment under PMLA.
No,
Final hear-
fresh matter or what?
Final hearing matter is already filed. a
Final
petition.
hearing, you file an application for urgent hearing.
Already petition
We
is
do
filed.
not permit, Mr. 14% doesn't mean that you are entitled to do whatever you feel like. Everybody we are telling, final hearing, file a date for fixing an early hearing, we will consider it.
Already filed a
Next.
petition, my lord.
My lord, senior counsel J. Prabhakar sir is online, my lord. He wants to make a mention.
Ah,
But
Yes.
subject to lordship's kind leave,
ah,
in that matter where there was a direction for inquiry in that IAS officer's case,
ah.
it is listed that IAS officer, the examination and the departmental disciplinary proceedings. But the whole proceedings are not being held in terms of the rules governing the IAS officers. So we have filed a fresh application if it can be taken up tomorrow. We want them to adhere to the rules for governing the disciplinary proceedings against an IAS officer.
Tuesday. You are after him, open up after a long time and now
No, day before
continuously
yesterday,
monitoring the case, right? Ah.
day before yesterday, we have attended the hearing on that day, we came to know, my lord.
No,
Now we
no.
shifted to Saturday.
Mr. Prabhakar, it's a lighter vein, right?
Yes.
So the writ petition is pending. It's not that you have filed it yesterday and you want to stay. It's
No,
pending
no,
for 5 years.
it-
All of a sudden you have woken up from deep slumps
No,
and
it-
now you want monitoring everything.
No,
This
nothing, not
behind
monitoring.
bars and everything, right?
No, not
Tuesday,
monthly, my lord.
Tuesday,
Saturday is
Tuesday.
posted for my cross-examination, that's all.
Tuesday, 20th September.
I
Yes.
will ask for deferment.
No, we will ask you when the petition was, appeal was filed or petition was filed, we will ask you. We don't remember, probably it's 2017 petition,
yes,
right?
yes,
Ah.
Yes, no, we are
That's why
filing
we
a
are
fresh
saying that
petition.
it is pending since 2017. All of a sudden you want everything to be done.
No, now inquiry is going
Yes.
on, that's why.
Fine.
I leave it to that. We'll make a
20th
mention on Saturday
September.
for adjournment.
20th
To stay,
September.
your lordship. Much obliged.
20th September. Yes.
I'm Veereshwar Melod,
Yes.
party in person.
Huh?
I'm K. Veereshwar Melod, party in person.
Ah. Yes.
I just please your lordships to hear Melod subjected. Kind permission to mention.
What is the matter? Why do you want the matter to be listed? Fresh
Not
petition.
I am not mentioning for the listing Melod, it is other
Right.
than Melod, to the exalted highness the President of India.
Huh?
Melod have addressed a complaint against a honorable
Mute.
judge of the honorable court.
Mute.
So, honorable chief
Huh?
justice Melod, it was forwarded.
No, Mr. Which petition? The mentioning is in connection with the petition, not like we are not sitting here to listen to your speech. Next.
No,
Next.
kindly my
Next.
matter be extended
Next.
for
My lord.
honorable judge.
Next.
My lord.
Item 1. Yes. Yes. Who is password? This is an appeal under section 18.
My lord, can you
Yes,
mention
all-
my lord?
Please, my lord.
Item 2.
My lord,
Facts are like this, Lord. Commissioner received information from the bank.
No. Received the information that an appeal lies under section 18 of debt recovery before debt recovery appellate tribunal. Three-judge bench of Honorable Supreme Court says so. In this petition, the petitioner has assailed the validity of the order dated 30th August 2020-23 passed by debt recovery tribunal in an appeal under the provisions of SURFACE Act, right? Whole thing, right? Then give him. You know, don't know. Paragraph 5 and 6, right? Then next paragraph. After quoting para 5 and 6 of WP 20342 of 23, you write admittedly against the aforesaid order and appeal lies under section 18 of the SURFACE Act. We are therefore not inclined. In view of aforesaid enunciation of law by Honorable Supreme Court, we are not inclined to entertain the petition. However, liberty is reserved to the petitioner to take recourse to the remedy which may be available to him under section 18 of the act. With the aforesaid liberty, the petition is disposed of. Yes.
Yes, Lordship, may please.
Sir, copy,
I filed this writ petition.
copy back tomorrow.
You
Extension
will
of
get it now, within 3 days, you are getting copies. Mister, we are monitoring the situation as per guidelines.
May please, your Lordship.
Hmm.
I filed this petition for the extension of.
Ah.
I got the seat in first.
No, mister, where is that RVMC college not completed?
Sorry, Lordship.
Where is the,
I did
this
not-
thing document that your father suffered a brain stroke? Nothing like, just
Father-
saying anything.
father Suffered, Lordship. Father loved.
Where is the document? There must
I
be a
did not-
treatment prescribed to
The
him.
time I could not file Lordship on the file.
File it.
And also.
Where is RVMC college? How can we entertain a
That is,
petition?
very sorry to urgently we have filed.
There
Lordship.
is no question of being sorry.
Before 9 it was over, Lordship. They permit me to for the second phase counseling, Lordship. And only 2 days, I came to know that the admission.
Why
was
we
closed.
don't understand. We have asked you the question, you are saying sorry. That doesn't solve the issue, right? So we will record that when a query was put why the college was not completed, learned counsel for the petitioner said he is sorry. So therefore petition has to be dismissed on account of non-joinder of necessary party. That is the college.
We will amend it, Lordship, otherwise. Permit me to amend.
Learned counsel for the petitioner prays for and is granted. How much time? No, we
Did not even download
Ah,
allotment,
yes.
they do not even pay the fee.
now, so tell us.
We received a message and
No. Why you did not even download the allotment, order of allotment, and what is the explanation?
we are not getting after 4/9, Lordship.
Huh?
Download.
Download it? No, what did you do? Till, when did you receive this? Allotment when it was allotted?
We-
Last date for joining is 2/9 lots.
No, when she was allotted a seat?
31/8. 31/8.
31/8.
4 days for given.
31/8. So,
I received a message on 2/9, Lordship.
where have you set 2/9?
26, Lordship.
Paragraph?
Page.
No, which affidavit? Yes,
Para 2 lots.
Yes.
Correct.
para 2.
Yes.
And the respondent who has given time for 4 days to report before the
Ah.
college honor for 2/9.
Then this is a 4 days time was given, there is no averment. Yes, sorry.
The same day I have received.
Sorry, sir.
2/9.
No need. Yes, nothing. This, the petitioner is meeting are over. So she can be permitted to appear in second round? No, but she is not. Representation. Uh, delay condone delay in representation, etc. Right? Condone with consent heard finding. Right? 3. I said. Yes. Next. No condonation of delay in this condonation. Yes. We have issued notice, right?
My Lordship, I am representing on behalf of petitioner. I request the Honorable Court to condone the delay of 91 days in representing the writ petition.
Yes.
Also, the senior council member is representing the current case, my Lordship, due to certain
IAS ones. Item 4 heard on IAS one. So delay in represent whatever is condoned, IA is allowed. Heard on the question of admission. From perusal of the record, it is evident that writ petition involving similar issues, namely WP number 32 come up along with that. We have already said. You are appealing for Mr.
327, my lord.
So everybody is represented, right?
Yes.
So no notice. Notice on behalf of 1 and 2 is accepted. You write, you can't write Mr. 327. Yes.
With kind permission, Your Honor.
Hmm.
Here, as per the doctrine of hierarchy of courts, the lower courts have to implement and execute the orders and directions of the Honorable High Court and as well as Honorable Supreme Court.
No, Mr. What are you seeking in this petition?
Your Honor, Your Lordship, this is a writ petition filed for writ of certiorari. Call for all the lower courts.
No, a call for record. What is no further relief? We will call for the records and keep it here.
Yes, Your Honor. Stay the proceedings, all the proceedings of the lower court. Why? Because they are violation.
Staying the proceeding.
Yes,
The execution proceeding.
Yes.
Right?
Yes.
So then tell us, come to cost title.
Yes.
Cost title of the petition.
Yes, Your Honor, here. Petitioner is Manohar.
1 minute. So we are entitled to ask you a question, right?
Yes.
So then how respondent number 2 and 3 are necessary party? How have you implemented them? What relief you are seeking against Registrar General of this court and Registrar Vigilance of this court?
Yes, Your Honor. Already we filed all written arguments before this honorable court. We filed written submissions.
Home guard, he will forget home guard, right? This we will impose such a this thing frivolous petition. Mr. How have you implemented Registrar General and Registrar Vigilance? Please explain.
Yes, Your Honor.
What is the relief which you have sought against them?
Yes, Your Honor. Here, exhibit number 1.
And how respondent number 4, the judge has been implemented. Who's this? The respondent number 4, why he has been implemented in personal capacity?
Yes, sir. Here, exhibit number 1.
Registrar General.
Exhibit number 1. Upon violation of national justice and provisions of law, we issued a notice on August 29, 2023.
No, in execution proceeding, which according to you are time barred, if a notice is issued to you, instead of filing an objection, you file a writ petition here, implead Registrar General, Registrar Vigilance, and the judge who issues notice in personal capacity.
Yes.
Right?
Yes, sir. We served the same to higher authority, high court higher authorities. Whatever we served the respondent number 4, that is lower court presiding officer, the same copies are sent to Registrar General and as well as Registrar Vigilance. And moreover, Your Honor, here exhibit number 3, Your Honor, copy of High Court orders. The Honorable High Court.
So you can file an objection to the execution petition. If this is the case, then every case, if you're impleading the highest authority, it's not appreciated.
But we know
Supreme Court has said
there is no
the practice of judicial impleading judicial officers who have passed an order has been deprecated. And you are impleading, we will impose a cost of 50,000 rupees while dismissing the petition. Right.
Your Honor,
What else you are?
Your Honor, here actually the suit schedule property is individual property, Your Honor.
We have understood.
Individual property.
We have understood. No, Mr. That's the thing, right? Unfortunate that in an execution proceeding, a notice is issued to you. You feel that it is time barred or illegal or whatever, arbitrary, whatever. Then you will file instead of filing an objection in execution proceeding, you will file a writ petition here. In that writ petition, you will implead Registrar General of this court, Registrar Vigilance of this court, and the judge who has directed issue of notice in the execution proceeding, you will implead him with personal capacity. And despite being told by the court twice, you are not taking action to amend the cost title. Then you are liable to pay cost of 50,000 rupees. Yes.
We amended the cost title, my lord.
Not amended. This is 2, 3 and 4 are already there. Honorable Registrar General.
My lord, we remove the parts. We remove the
Register, if you understand, if you are amenable to logic, then the remedy of the petitioner lies in filing an objection before the executive court. We will direct that in case such an objection is filed, executive court shall adhere to the objections filed by you. That we can say.
Justice has been violated. Natural justice and provisions of law.
You don't understand anything. What can be done? That's why we said in the beginning that if you are unable to logic, then we made a suggestion. Otherwise, we will pass an order. You argue natural justice. Before issuing notice, you will file natural justice, then no other can be passed in any case. They have not passed the final order. He has only issued notice of execution proceeding. Then where is the question of violation of natural justice? What is thoroughly, Mister? You have not done law, right? You have not done law. You have not read it, administrative law, principles of natural justice. Nothing you have read. No decisions of Supreme Court. No, we are dismissing the petition. Yes. Dismissing the petition with imposing a cost of 50,000 rupees. The practice of impleading judicial officers has been deprecated by Supreme Court. You don't understand. Yes. In this rate petition, comma, the petitioner mark the presence in this rate petition. In this rate petition, comma, the petitioner inter alia has.
Your lordship, sir, excuse me, and we will file apology petition before the on report.
No, apology, that doesn't make any difference, apology. The fact remains Registrar General is a party. In this writ petition, comma, the petitioner has prayed for the following relief.
We withdraw 40, sir. We withdraw 40.
Withdraw the petition.
Yes.
Better withdraw it. After arguing the matter to some extent, learned counsel for the petitioners.
I beg to appear.
Yes, this is, we have issued yesterday instructions to the registry that registry should not refuse to register the petition on the ground. This is a question to be dealt with by the court. So we will direct the registry to register your petition and hear you on Monday. Learned Senior Counsel office is directed to register the writ petition. Correct? How can they say that alternative?
I believe it should be on Tuesday.
We will decide when a franchise, what happens that they should put a note that there is an implementation engine. They cannot see, this is orders of the court means they're not registering on the ground or something. When we hear, we will decide whether it will be regulated, what else to be said. They can't say. Yes. Mark the presence, learned senior office is directed to register the petition. List the same for.
Tuesday.
Tuesday, 20th September.
Tuesday may be 19th.
19th.
Tuesday may be 19th.
What you have written, madam, here. Please see. See, that's why the problem is arising. These people have given a chart to us. There they have listed wrongly and repeatedly telling me something else. I am looking at it and give it a fresh printout. 19th, Tuesday, whatever.
Right.
Same order in item 7. Give me a fresh printout, Mr. He is sitting there. Printout, fresh. Yes. Same order, madam. Tuesday. Yes, Mr. Reddy.
Please, lords. EL file for the flood affected.
No, this flood victim, we are already entered you. There's no, in Mr. Reddy's, this Prabhakar's case, we have passed several.
Bill 196 of 2020.
I am not aware of that case, lordship.
The not aware means you can't file.
Even in the pay also, there is no.
That doesn't mean that you are not aware about so many things that what is the capital of Sweden, so you will file a writ petition. I am not aware. There is whether there is a post office in South Pole, not aware. Therefore, I will file a petition. Nothing.
But that case
In
not
this
in the
public
year
in- nothing.
23, not 23.
We know this. You don't have, you are not a flood victim. Are you a flood victim?
He is a social,
Are you a flood victim?
he is a social worker.
We are asking you, Mister, the answer the straight question. You are not a flood victim.
Yes, Lordship.
You are a flood victim, then file a petition. Learned counsel, you are seeking a relief of 50 lakhs and 20 lakhs, whatever in this petition, right?
Yes, Lordship.
Then the petitioner submits that he is a, this petition has been filed as public interest litigation in which following relief has been claimed. Full stop. The writ petition involving similar issue has namely bill number 196/2020 has already been entertained where so did you understand that you are a flood victim and you want compensation, right? This is what you have told us.
He is a public social worker.
Then you want this thing. Aggrieved person means.
He is a
You
social
understand,
worker.
you are not.
He is a social worker, Lordship. He is a student agitator. He filed the.
Who said he is an aggrieved person, flood
Not,
victim?
not Lordship. I have stated that.
This is what you have said.
Of the second page number 10, paragraph
Yes,
number
but
2.
this is what you said that he is an aggrieved person and
He
is
is
a
not
flood
a
victim.
but he is a public social worker.
So you are also a social worker, are you not?
Yes.
You are a social worker or not? When you
Social
do.
worker.
No,
I stated that.
Mr. What we are saying, you are also a social worker. When you do a work free of cost, many litigants you must be doing.
Yes.
So you are also a social worker providing legal assistance to needy people. He is not
But,
only the social worker. Yes, next. In this writ petition filed as a public interest litigation, yes, madam, all madam, item 10, 9. Yes.
May it please, my lord.
Hmm.
This is.
Same, madam, this is pending, right? Flood victim.
With
Yes, my
respect
lord.
to the
Yeah.
respondents,
Victims, my lord.
well, the respondents, she made the cabinet secretary as a respondent. The respondent, Lakshmi, kindly see, principal secretary to central government and home secretary and cabinet secretary. Response should be made by Union of India, represented by so and so. No representation has been made by none of the respondents here.
The BJP party, Congress party, every party, right? You are contesting an election, right?
CEOs.
No, my lord, I am not at all contesting as an election campaign and all that. This is filed for national mission, national contingency fund is there, my lord.
No, madam. What is the prayer in the petition?
In the petition to release the amount from the national calamity contingency fund. my lord.
See what is Union of, how have you implemented Union of India? Is this the way?
They are the persons, they have to release the funds, my lord. P3 is the national calamity scheme, my lord. That is the page number 43, 49, my lord. Shall I?
Please go ahead. It's your petition. We will pass an order. Whatever we wanted to tell you, we have told you. Respondent number 5, 6, 7. How respondents can be pleaded? 1 minute. How this thing? CNN, IBN and this thing channels are necessary parties, we don't know.
Yes, my lord.
If the.
I will explain it, my lord.
Please explain.
But they are the persons, those who visited there and they published in the TVs and they went there.
So TVs will give the fund to you.
No, my lord.
Then
Only inform.
why have you implemented?
If your lordships says that how you got this information and all that, that I have to prove it. Because of that, I made them as parties. Because they will be having that videos and all that. I am not having that videos.
Online videos, sir.
Yes, madam.
If your lordships permit me, I will withdraw that all the 4 members. No problem for that.
No problem.
Yeah, according to us, none of the respondents have been implemented properly. You will have to make an application for correction of the cost title according to us. Subject to what you are at liberty to argue.
Yes,
Whatever, we will pass an order. Please argue on admin. This is on.
Your
this
lordship,
thing.
kindly see my order in 2009 also. I have filed this same petition. That was allowed. My
No, madam, are you aware that this thing, this another public interest litigation is already pending where we have issued directions to the
Same
state
with-
government, flood victims, say very same relief.
National Calamity Contingency Fund.
Hmm.
On that fund, your lordship, may grant. Yes, it is a known fact to everyone, but I implemented them only because of that videos. If your lordships asks me videos and all that, I have to prove it. Because of that, I filed. Madam. Page number 43 and 49.
Have you seen the prayer made in WP 196 of 2020?
Madam.
This is the, madam,
Madam.
office has raised an objection.
Huh.
Did you go through the objection raised by the office? You are straightway arguing. This is
complied.
on office objection, right?
I complied all the objections.
The
madam.
relief claimed in your petition, number 2 things we are asking you.
1,000
1
crores.
minute.
1,000 crores, madam.
Alright, let it be 50,000 crores, madam. Why 1,000 crore? 50, make 50,000 crore. Why 1,000?
No,
You are not prepared to understand what can be done.
you are,
If you don't want to understand the question,
No, I am.
you, madam, then, so we are sorry. You have not read the office objection. Have you read it?
Yes, madam.
What is the office objection?
That objection copy is not there. It is with your lordships.
You have read it, madam.
I have complied, madam. I have complied each and every objection. After that only, I went to registrar's office. Register, deputy registrar and both registrars are there.
Yes, argue whatever you want.
I may be permitted to see it, my lord, after completion of this. Exhibit P1, my lord, 36 and 40, my lord, page number 36 and 40, my lord.
Yes, 36.
This is 2020 with regard to 2020, my lord, this prayer, my learned friend gave it to me. Your lordship may kindly see the pages, this order number, my lord.
Proceed faster, madam. This is not like something like asking review of Keshwanand Bharti. You are only demanding 100 crores from central government for flood victims.
Yes, ma'am.
So then proceed faster.
Yes,
Everybody else is waiting, right?
Yes.
Please
I'm sorry.
be considerate and kind to your
Yes,
fellow
I'm
colleagues practicing at the bar. Yes.
order, my lord, in P1, exhibit P1, 49, page number 49, madam. In this public interest litigation, sum and substances of the prayer made is that the central government is directed to render necessary assistance to Andhra Pradesh government. As they said, state has suffered because of floods in the month of October 2009, my lord. It has been submitted that if the incident is considered as national calamity, substantial financial help can be given to the state. The learned Assistant General, Solicitor General A. Rajshekar Reddy garu has appeared for respondent number 1, 4 and 5 and has placed on record a counter affidavit filed by the Director Home Affairs. It has been submitted by the learned Assistant Solicitor General that there is nothing like a declaration of national calamity, but under a scheme named National Calamity Contingency Fund NCCF, under this only I am contesting, madam. Like cyclone, drought, earthquake, fire, flood, and hailstorm, if it is of a severe nature. This is the order, my lord, and it was given Assistant Solicitor General to not dispute the fact that the floods with which the state of Andhra Pradesh was affected was of severe nature. It has been submitted by him that interministerial general team had visited the state of Andhra Pradesh from 26th to 29th October 2009 to assess the situation so as to ascertain the damage caused and prepare its report. The report to be prepared would be submitted to the high-level committee, which is headed by the Honorable Union Financial Minister, and thereafter appropriate decision with regard to rendering financial help to the state would be taken. Again, that was the final order was passed on.
No, that was past. I mean, that we can't examine in this writ petition. Yes, madam.
Final,
And this petition is different, right? That is different.
same, same.
Same means then why have you filed the petition if it is the same?
Floods are same. Floods are same, and only difference is that Andhra Pradesh is divided into two.
And the floods have come this year, not whenever you filed the petition.
2009, my lord.
So we are in
They
23,
have released already.
14 years. You are referring to an order 14 years ago.
Yes, my lord. On the day, so the same floods came up. Same floods, my lord.
We don't know.
This
state
is
floods.
2009 floods, and they released 800 crores. They released. I will read it. On the basis of this petition only, they.
Madam, you have not read the office objection. All the best to you. What can be done? Anything else?
I will.
As for 2000, no. You are arguing now. Yes. What else? 800 crores released in 2009 floods.
Yes, ma'am.
Therefore, it should be 1600 crores. Why you have limited to 1000 crores?
No,
It should be double.
that is the estimation of the government of state government.
Release.
That financial, and for they have said it in the.
And you are sure
It
that
is-
1 minute. You are sure that government has not made any claim, right? You are the only person who here to make a claim on behalf of government of Telangana. Government.
Not like that, my lord, I am only a social worker. On behalf of only people, those who affected is only poor people, but not the higher class people and the upper middle class people. Only poor people are suffering due to this floods and all that. They were not given any assistance.
Anything else?
We will suffer.
This is not a speech, right? This is not.
I am not giving any speech, my lord.
Please argue on law. Okay.
Law,
So therefore, under which provision they should give 1000 crores to the state of
Yes.
Telangana?
that I will pay.
Ah.
Your lordship may kindly see the NCCF 43 and 49, page number 43 and 49, my lord.
Yes, scheme. Under this scheme, they should give 1000 crores. Right.
More than that also they can pay.
More than that. Whatever they want, they can give. In addition
Give
to,
the application, but they have not given the application.
your minimum claim is 1000 crores and it is their choice. They can give more also.
More or less,
Less also.
less also.
Yes. What else? See, this is the office objection. This is the office which will same. Even in this also. Even in this also. Yes. Okay. Yes. No, we don't want to competition otherwise. This team, they will be. Yes. Yes, madam. Anything else?
This is National Calamity Contingency Fund, my lord. The scheme shall be called the National Calamity Contingency Fund scheme. But the second one is natural calamities of cyclone, drought, earthquake, etc. my lord. It is mentioned. Fourth one is a National Calamity Contingency Fund here and after referred, that is not necessary. The fifth one, my lord, the initial corpus of the national fund shall be rupees 500 crores to be provided by the government of India, madam. It is there, madam. According to that, I am asking. Transfer of national fund will be made under the minor head 797, my lord. 5.3, my lord. An amount of rupees 500 crores being initial corpus shall be transferred to the national fund under a new minor head. It is stated, my lord. The debits of the major 22245, my lord. 6.1 is National Center for
No, that is correct, madam. How have you implemented respondent number 5, 6 and
yes, I will remove.
7,
No problem for that.
8, 9,
Removement.
5, 6, 8,
Seven.
9.
8 and 9.
Ah.
I will withdraw it. I will remove the, immediately I will remove and I will correct it, cost title, I will file.
Learned council, how much time you pray for to make an application for deletion?
15 days.
Learned council
Including
for
that,
the
they should
petitioner.
make an necessary application to the immediate
You
response.
file an objection also to this. Because according to her, any officer, you should thank God that she has not implemented the principal secretary, government of India by name.
My lord.
How this is can be done, madam, you explain on the next date of hearing. Then again on next date, you will pray for another 15 days. We want.
The special direction was there at that time, stating that you have not implemented these persons.
We understand if Union of India is implemented, that is understandable, but you are implementing officers by designation, whether that can be done, that is another issue you will have to address.
To implement at that time, my lord. I was asked,
Nobody has asked you, this is coming up for the first time.
Document also. I will file that document also. I will file.
No, nobody has asked, madam, this is what.
This honorable court itself asked.
No, I did not ask. I saw you for the first time today when you are appearing. Is it not your first appearance before this court? Then I was not there to tell.
No.
This all good. No, madam, this is not fair. This is not fair.
In the year 2009, I was.
Then go there who had asked. Go to them. They are not here.
Implementing only they passed this order, my lord. After implementing only they passed this order.
All right, you argue on the next date.
Yes.
We will see if we don't agree, it will be dismissed on this very ground that they have not been properly implemented.
Yes.
You argue next date.
Yes.
So now you are praying for time to delete 5, 6, 8 and 9, right?
8 and 9, I will delete it.
Learned, when a query was put to learned counsel for the petitioner, no.
May be permitted to delete the names of it.
No, you file an application, madam. 2 weeks time you have been granted to delete. Yes.
Your lord.
No. Ah,
We are fine. And affidavit, your lordship, it may be taken up next week, your will file detailed affidavit with regard to this.
Arey, madam, this repeatedly it's coming up. I am only 7, 8 weeks old and this matter must have, and she must have appeared 8 times. We will admit it. What is there?
Your
Oh,
lordship,
this
give the instructions to your lordship and await.
appeal is admitted. Please file an application for urgent hearing, madam. Repeatedly, this is appeal is admitted for hearing. Learned count additional government advocate. Praise fund is granted. How much time?
2 weeks, your lordship.
What 2 weeks? We have admitted. That's why.
One
This
week,
is
your
not fair, madam.
1 week,
Not
your
fair.
lordship.
You said initially 1 week. The moment we admitted, you are saying 2 weeks. Not fair. We watch your conduct all the time.
Next week.
No, you first tell us why it has not been done. Till today, why, and the person who has to file an affidavit and why he has not done it. Offer file an affidavit explaining the delay. Delete, madam, the order. Write her name. We, madam, watch the conduct all the time. This is not fair. Smiling is no solution.
No,
Your conduct is in question.
next week, your lordship.
Why-
Fine.
Why did you not do it despite an order on 21st August?
According to the your lordship, the letter
Ah.
was not addressed and according to the
5th
provision.
of September, was just a minute,
Your lordship.
other 5th of September we had given. So this thing, letter you along with affidavit of the person, why it has not been done?
According to the instructions, your lordship, according to the provisions, the letter is not necessary to send to the gazette notification of the state, your lordship. And we have received the instructions. We want
No,
to file an
letter, we have said letter if any along with affidavit of the person. Why have you not filed an affidavit?
We have received an instruction in a form.
Who
of
has to
instruction,
file
your
an
lordship.
affidavit? Who has to file an affidavit? When did you send a letter to that person? When did you inform him that he is required to swear in? Oh, so he is required to swear in an affidavit. When did you tell him? 5th of September 23 order was passed.
Yes.
When did you,
District collector, your lordship.
where?
మాట్లాడిన తర్వాత వీళ్ళ అడ్రస్
Sorry, your lordship, the letter. We'll file a detailed affidavit, your lordship, when we have addressed a letter and when we have received the instructions from the office.
Your
Mark
lordship,
the
if I
presence.
I'm sorry.
Mark the presence. Despite order dated 5/9/2023, an affidavit, neither the letter nor has been neither Madam, don't try to be smart with the court. This is the thing which we desist. Don't ever try to be smart with the court. Just trying to pull a fast one, saying 1 week we agreed, then say 2 weeks. You are not here to do these tricks. You are not a magician. An officer of the court, at times under an obligation to behave sensibly, more so when you hold the brief for the government. You are interested in subject matter of this appeal.
Especially please,
No, you are interested in subject matter. Then why are you doing like this? She has suffered an order, mister. She will explain it to you. The collector is in difficulty. Because of her, the collector is in difficulty. Because of her conduct, you please comply with the order. If it is not complied with, we will direct. You read, better get the copy of the order. Ask your colleague what she has done. She will tell you. Mister, what she said that 5th September direction, we want 1 week time. So we were granting that time. I told senior counsel that this appeal is repeatedly coming before me, correct?
Yeah, sure.
So we admitted the appeal. Then I asked, within how much time will you file? She said 2 weeks. So that means initially said 1 week. Now thereafter, just because we admitted the appeal, she said 2 weeks. So what we have told her, we don't like people to play smart with us, right? So, and therefore collector has been directed to file an affidavit by 20th September. That is Tuesday. Whatever is 20th September.
It's 19th
That why affidavit directions contained in the order on 5th of September 2023 have not been complied with, right? First of all, he will file, explain the circumstances, why the order dated 5/9, that will include also when did you receive the, send the communication to him. She is unable to tell. We have recorded that she is unable to explain why order dated 5th of September 23 has not been complied with. We have recorded also.
We have received.
Government should thank for engaging such councils itself. Yes, no, nothing, no apology. We are not sitting here to get this, we mean business. This is the order. We have asked you. If he doesn't file an affidavit on 20th September explaining the circumstances of non-compliance of the order dated 5th of September, he will face the consequences.
We'll file it. I'm sorry.
Yes.
Light your lordships. I
Please,
I
your lords,
request your lordship.
learned senior counsel bigger.
Oh,
My name is reflecting for R4.
no, you are not appearing, right?
I'm not appearing.
Fine, be happy. Yes. Yes, madam.
Your lordships, the IA was filed, your lordships,
Hmm.
explaining, another additional counter affidavit was filed by the respondents, your lordships,
Hmm.
explaining as to why,
Where is that affidavit? You are fine.
your lordships, here, your lordships.
This is affidavit.
Yes, I believe so, your lordship.
Yes. Oh. Like virtually a paper book thicker than writ petition, right? Huh? Like throw all the garbage on the head of the court. Court will deal with it, right?
If your lordships would turn to paragraph 4, your lordships, on page 3 of the
One
material
minute, one
documents.
Let him explain, then we will hear you.
Yes.
Yes, what is?
My lord, yes, because your lordship had thought I put all the internal correspondence as well, my lord, before your lordship. Because the question that your lordship posed, my lord, that why have we not cancelled the LOI of R4? Therefore, even the internal correspondence of how we have extended his.
What is it, Mr.?
Yes, my lord.
Like giving, filing how many pages? 276 pages when we ask you to file an affidavit. Like was throwing 276 pages on the head of the court. That's why you are here to assist us, or we should read it. Sit down then. We will read it and find out what is it. Yes.
Your lordships, I'll only
1
take.
minute, madam. We will have to go through the affidavit
Yes.
now. He is not telling us what is the affidavit about. So what
I will
can we do?
explain. I will explain, my lord. My lord, I'm in a position to explain, my lord.
Yes.
May I submit? Yes, my lord. My lord, insofar as respondent 4 is concerned, my lord, he is now, my lord, he needs a DTCP license, my lord, from the government. My lord,
Fund number 4 has been served with the notice of
Yes,
the
yes,
subsidy.
your lordships, and he's not turning up.
Not turning up.
He's not turning
No,
up.
but somebody was saying that you are not appearing, right?
Presently, I'm not, I don't have any instructions from the client.
You are not appearing.
No,
Fine,
I don't
sit.
have any instructions. My name
Yes.
was reflecting, it has to be deleted.
We will delete.
Okay.
We will delete.
Proof of service also is filed, your lordships.
So, right, the office is directed to delete the name of
For Varun,
we can extend the LOI insofar as candidates, my lord, who, though their land is within the requirements of the notification, my lord, but they are unable to progress due to getting permissions from the government authorities, my lord. In such circumstances, my lord, there are guidelines in which we can extend the LOI. Now, those guidelines, your lordship will find at page 86, my lord, of this affidavit, my lord. May I invite your lordship's notice to page 86, my lord.
So what is this thing, clause 5.1 of LOI, what do you say? The affidavit is silent with regard to. You have only said that if we cancel it, then again, long process. Same was with the petitioner also. Why did you?
Yes, my lord. In the case of the petitioner, my lord, how much ever time she takes, she's not going to get. Her case was not that she needs more time to get the permission, my lord. Her case is that she will not get the permission from the railway authorities because it was too close to the track. Had her case been that she needs more time, then she would have been considered for extension of LOI, my lord. But in any scenario, she says that she cannot get that permission.
What is the status of respondent number 4?
Respondent number 4 has been given extension till 31st October 2023, my lord.
Failing which?
Failing which his LOI will be cancelled, my lord.
All right. Yes, ma'am.
And those, I have also filed, my lord, the internal correspondence and the permission has been given by the competent authority, my lord. Your lordships will find that at page 43, my lord, of my affidavit. That's the internal correspondence and the permission given by the competent authority, my lord, at page 43, my lord. My lord, the petitioner has to make a permission, my lord, make an application to the authority, my lord, the IOS.
Yes.
Obliged.
Your lordships, if I may, your lordships, the bias and the duplicity of the respondents can be seen from this, your lordships. Your
No,
lordships.
but you have challenged the order dated 18/2/2020.
Yes, your lordship.
What is wrong with that order?
That itself, your lordships, here, your lordships.
So what are the grounds, madam?
The grounds are that, your lordships, after making several requests, your lordships, after also obtaining an ALA conversion and lease, when the railway authorities had not given us permission, your lordships, we have regularly corresponded with them, your lordships, and informed them that another place was available and we are waiting for your permission to start commissioning there, your lordships. There, your lordships, in spite of there being an interim order of this.
When you have taken the land on the other land on lease, you tell us this thing, your LOI was accepted, issued on
Your
20th
Lordship.
August 2018, madam.
Yes,
correct?
your lordships. And
Then
then
thereafter, 1 minute. So within how much time you were required to commission the distributorship?
4
as
months,
per
your lordship.
4 months. That
Months
means up,
according to 5-1.
huh?
According to the same clause 5-1, your
So
lordships.
up to 20th, 19th December 2018.
Yes, your lordships.
So you did not do it because of the railway
Yes,
track.
yes, your lordships.
Then when did you offer, 1 minute, when did you offer the alternate land to the, this thing, IOCS?
During the pendency of this writ petition, your lordship.
Date.
Your lordship.
Month also will do or date
Yes.
will also.
Yes, your lordships. Your lordships on page 73, your lordships.
No date.
Page 73.
No date.
Orders challenging, your lordships, the writ petition, your lordships, the previous writ
Date
petition.
on which you offered the alternate land.
Please read, your lordships, 27/2/2019. It's on pages 79 to 82.
On
27/2/2019. It's on pages 79 to 82. And the land conversion proceedings of the said land also. And the permission was on 30th/7/2019, pages 83 to 84.
conversion proceeding.
Yes, your lordship. Land
37.
conversion proceedings on page 83 to 84.
Date, no, the order. Date, madam.
Date 30th/7/2019.
Order.
And then the Gram Panchayat construction permit as well, your lordships. It's dated 7/9/2019. That is on pages 85 to 86.
All right.
Your lordships, an aspect
And
your lord,
18th February, your request has been rejected.
yes, your lordships.
All-
Your lordships,
Which page? 18 to 20.
request,
18.
South Central Railway rejection letter on 6/11/2019. It's on page 78. On page
6/11.
78. 6/11/2019.
We are asking about 18th February 20 order.
Your
Which
lordships,
page? Issued by IOCL. Arey, mister, which page of, you don't know? Which page
63,
of?
your lordships. Page 63. 18,
Yes, 63.
page 63 and 64.
Yes.
It's on 18/2/2020, your lordships, 63 and 64. Much after I have gotten alternate land, permission for the same, Nala conversion for the same, as well as construction permit as well, and I was ready to install it, your lordships. After that also, they waited for 4 months and then they unceremoniously rejected me, your lordships. I also come under the same SC quota itself, your lordships.
No, madam, there is something right, this thing.
Yeah.
Incorrect about the dates which you have told us. Letter of intent was issued on 20th August 2018. correct?
Yes.
Then up to 19/12/2018, you were required to commission the distributorship, right?
Yes,
You said that you offered alternate land on 27/2/2019. Which doesn't appear to be correct because this, we don't know, please point out page 63, last this thing. You submitted a letter on 7/11/19 requesting for alternate land. So this can't, it is not February, is it November?
on page 79, your lordships.
63, the order of rejection. Last but one para. You had submitted a letter 7/11.
Yes, your lordships.
No, but you said that you had submitted on 27 February 2019.
27 February 2019 is the lease deed for the alternate land, your lordships. Once I got all,
You told us that we offered the land. No, we did not offer.
I was continuously in negotiations with the South Central Railways. They did not accept and they did not deny. While they were in the process of accepting or giving me an answer, I found an alternate place. I informed the IOCL about the alternate place. I got the Nala conversion for that alternate place.
So 7/11/2019 you requested
Yes.
to IOC.
IOCL rejected. The South Central Railway rejection letter is dated 6/11/2019, Your Lordships. It's on
In
page
respect
78.
of alternate land, right?
In respect of the railway, land close to the railway,
Initial land.
initial land. In respect of that initial land,
Land which was initially offered by you,
yes, Your Lordship.
it was rejected. Thereafter, immediately the next day, you gave an alternate land.
Yes. Before informing them about the alternate land, I got.
What are the minutes of meeting dated, minutes signed on 10/10/2019, Mr.? You said everything, internal correspondence, everything. 10/10/19.
141, Your Lordship.
1 minute. 141.
Yes.
10/10/2019.
No, this is 30th December 141. 2009 something.
10/10/2019.
The Lordship is looking at my affidavit, not in the writ
It's in-
appeal.
it's in the-
Petitioners,
No, Mister. We are come to page 63.
I have seen, my lord.
Huh?
Yes, my lord, 63.
141 of the-
At
Appeal,
141 of the
appeal.
writ appeal.
Oh.
Yes.
141. Yes, fine.
Your
So
Lordship.
what can we, tell us what can we really do? This, as per letter of intent, this area where the location was notified, you initially offered the land.
Yes, Your Lordships.
The railway authorities rejected because it's near this the railway track.
Yes, Your
Obviously, safety reason.
Yes, yes,
You
Your Lordship.
cannot endanger other people
Yes, Your Lordship.
traveling by train because you want a dealership. So you offered other place. They say it's no. They have not agreed. What can be done?
Here, Your Lordships.
What is wrong with the order?
The publicity, Your Lordships. Here, Your Lordships, clearly in the minutes, Your Lordships, on page 142, they have given me 1 more month to start commissioning. Immediately, as soon as I got the railway authorities rejection on 6/11/2019, Your Lordships, that is 6/11/2019, after the minutes of this meeting, Your Lordships, I immediately informed them on 7/11, within 1 month itself, that I have been continuously talking to you about the alternate land, the lease arrangement, the Nala conversion, as well as the Gram Panchayat construction permit. Kindly allow me to construct. That is in November, 7/11/2019. They take another 4 months. On 18/2/2020, unceremoniously, they cancelled my permission, Your Lordships. Then the respondent number 4 is granted the commissioning, Your Lordships, way back in 2020 itself. We are in 2023 and they are making excuses for respondent number 4 for not starting commissioning. Your Lordships may kindly in the counter filed by the respondent.
Yes, but
Your lordships, paragraph 4 of the counter affidavit, your lordships, shows all the dates since
no, so
2020.
what is your, what are your submissions, madam? We have understood, we have heard you at great length.
Yes, your
So
lordship. My
please tell
submissions
the
are that, your
submissions are
lordships.
number one.
Yeah, the first submission is that, your lordships, the LOI
Dated
given
18 to 2020, why it should be set aside and
You-
what is wrong with the order passed by learned single judge?
Your lordships, the order, the learned single judge, your lordships, did not take into consideration certain rules, your lordships, that give us permission to change the land, your lordships, once the initial land is not available for any reason, your lordship.
Permission
Made
is-
that.
They have to, madam, it is their, this thing, distributorship. Who will decide the location? The person granting the, you can't decide that I will set it up here.
Yes, your lordships, it is for the respondents. However, here, your lordships, the respondents did not give me an opportunity to show that also, your lordships, and that aspect was not considered, your lordships. Because already 4 months' time has passed, long time back. But here, without even giving me an opportunity to show the alternate land, it was rejected, your lordships. Then, your lordships, the LOI to respondent number 4 is given on 15/12/2021. It's in the fourth paragraph of the counter file, your lordships, that your lordships had recently.
They should cancel, right? That
Yeah.
they are giving a long rope.
Yes, yes, your lordships. And that long row is given under the wrong guidelines, your lordships. If your lordships would once turn to page 86 of the counter, it is under the unified guidelines of 2016. Very conveniently, your lordships, which guidelines have the power to extend. This contract is under 2017, and specifically in 2017, there is no guideline for extension. It is only ad hoc upon my request. If they want to consider, they'll consider, or they will deny. So in order to give unfair advantage to respondent number 4, or rather to give him an excuse, they have backdated the unified guidelines. Page 86, the unified guidelines, your lordships.
Nobody is related to in IOCL to respond number 4. Nobody will put, we can tell you, madam, nobody in a government company will put his job at stake
Yes.
by forging the document
It's not
just to favor
your
the
lordships.
candidate. This is too far.
It's not for
Who has,
your lordships.
antedated? Who has, there is no person.
Antedated. I'm only stating that
You said just now, you said antedated.
the unified guidelines are of 2016, your lordships, and they are not applicable for this present contract.
They have been wrongly applied, understandable, but not antedated.
It's not antedated, your lordships.
Wrongly applied, we can
Wrongly
understand.
applied, your lordships.
Yes.
Section 1017, extension of LOI, which is part of unified guidelines of 2016, is inapplicable to the present contract, your lordships.
Yes.
And hence no formality of extension or no formality of giving extension can be taken on board. Another aspect, your lordships, the unified guidelines in the counter start from page 46, your lordships. It's clearly from July 2016. Then, your lordships, on page 4 of the counter affidavit, the respondents have stated that paragraph 5, it is respectfully submitted that the corporation has correspondent with LOI holder time to time, directing him to speed up the commissioning of the distributorship. The petitioner has cited various reasons for delaying, including lockdown during corona, delay of government authorities, etc. As the LOI holder is belonging to social, objective, and economically poor background, and also there is significant progress in construction of the go down, and also delay happened in obtaining the statutory permissions. There is no progress at all, your lordships, as on this day. I have already submitted photographs previously, your lordships. These are the photographs as on September 11th. Absolutely no permission. And this point, your lordships, has been reiterated by the respondents in two counters. They filed a brief counter previously in which they stated there is speedy construction, your lordships. And then they filed another counter under your lordships instructions. In this also they claim that there is speedy progress. No, respondent number 4 is not appearing. Respondent number 4 is not commencing with the work. Respondent number 4 is being continuously given a long row.
Will suffer the consequences.
Your
If you not appearing, not completing.
Yes,
the
your
third
lordship.
thing is, he will suffer consequences.
Your lordships, here, your lordships, I have given the alternate land much before the time they allowed me to.
We have
And it has been wrongly denied, your lordships. And another aspect, your lordships, in their counter, in the writ
Page
appeal,
29,
they
Malad, he
they
stated his
claim
survey
to
number,
some
Malad, as it is
915,
Malad
your
in
lordships.
109.
January 2014
That
to March 2014.
proviso is not available
The
anywhere,
petitioner
your
number one
lordships.
was
I don't know
examined
from
as
where they
PW.
got it. I
Petitioner
mean,
number one is the
they
mother
should
of the
be the
deceased.
ones.
And during her cross-examination, she elicited that she is the mother of the
Your lordships, on page 41 of the writ appeal is the counter of the official respondent, your lordships. They claim it is humbly submitted that the petitioner stated in para 10 of affidavit that it is also taken to the notice of the respondents that the change of site at LOI stage may be allowed at any number of times per the policy in vogue. It is pertinent to mention that as per guidelines 9.1.2, it is a one-time option of offering the alternate land. There is no existence of this 9.1.2, your lordships. Not in the unified guidelines, not as part of the LOI, nothing. In fact, on page 119 of the unified guidelines, clearly it states of the writ affidavit, of the writ documents itself, 119, at 18 and 19, that after field inspection, if an alternate land, for whatever reason, it's not suitable and an alternate land is offered, then they should conduct the field inspection of that alternate land. Here I have submitted the alternate land after getting all permissions and ready to commission at the time. On 7/11/2019, when the time they gave me on the date of the meeting is from 10/10/2019, 1 month. Well, within that time itself, I informed them. And then they unceremoniously rejected my LOI on 18/2/2020, which again is bad in law, your lordships. And
Today I am
the
not sitting.
2016
Tuesday motion
guidelines,
list.
which have specific criteria for extension legally, your lordships, those guidelines are not applicable to my present case, your lordships, because my contract is after 2017, your lordships.
Vidyamangalaram, purchaser, legal aid. No, purchaser or legal aid?
Yes.
Legal aid. Family member. 1 minute.
We should be given this instruction. We have mentioned of your time that will go to the party.
No,
Yes,
purchaser
what
or
else?
legal aid?
Your lordships, on page 50, your lordships, page 49, yes.
Legal aid.
Not pressed, it is not disposed of on merits.
Malad, it is so.
Request for testing account. We have to and run leadership. Can't be done.
Your lordships, just one.
Yes.
Your lordships,
We
page
have heard you, madam, like enough.
Yes, your lordships.
If you want us to admit, we will admit, it will come after 10 years.
Your lordships, just that, your lordships, and as As far as redrawing of lots, council mentioned last time that even if the petitioner cannot be, is found to win your lordships, he cannot be given because they have to redraw the lots. Here, your lordships, they did not redraw the lots the first time itself. The respondent number 4 was the immediate second person. So if they did not give it to petitioner to the petitioner, your lordships, they ought to have redrawn. They did not redraw the lots, your lordships, and they immediately handed to the second person, your lordships, who's not representing right now. Hence, it should be granted to the petitioner, your lordships. I'm obliged.
All right, yes.
Para 8 minutes, just above para 9.
Right, appearances,
Maybe
and then
6, 7 lines
delete,
from the
then
Right.
12.
Lordship. Lordship, this writ appeal on previous occasion. I sought your lordships kindly file a memo, my lordship.
Huh?
Sir, on the last occasion, I sought your lordships kindly to file a memo. To bring,
Reply affidavit.
yes, my
filed
lordship,
in
that
the-
was filed, my lordship, on that.
When have you filed?
On the same day, 4/8.
When, madam, it has been filed, reply affidavit.
USR number may I give? 73325. 73325 of 2023.
Hmm.
That by mistake, the reply affidavit was omitted, I sought leave. I filed it.
Filed?
Yes, your lordship.
Learned
Will
counsel
be
for the
73325.
applicant submits that the reply affidavit filed in the writ petition has been filed on 4/8/2023. However, same is not on record. Office is directed to trace the same and place it.
I leave it, your lordship. That is
Item number 10, order has been passed.
much obliged.
We don't know. Yes. 30. Yes.
My lord, I am appearing for the petitioner. My lord, in this matter, there is an order passed by the CMM under section 14. CMS stroke DM under section 14.
Stroke DM? What
Yes.
is CM, Chief Minister?
No, the Chief Metropolitan Magistrate under section
Then,
14.
Mr. We are not accustomed to abbreviation. CM and DM and PM and FM and who else? LM, LM also.
My lord, under section 14 of the Surface I Act.
Whatever, Mister, you take, if you want to take possession,
Yes.
you file, you initiate proceeding under section 14 before the Chief Metropolitan Magistrate of Surface Act.
Yes, my lord.
Why are you challenging the order passed by Tehsildar?
Sorry, my lord.
You are challenging the order passed by Tehsildar in this writ petition.
My lord. Actually, I am not challenging. Actually, I am telling to implement that order. Now, let me see what on a district magistrate passed the order and.
No, Mister, the predicament is, the problem is that you don't know what is the relief claim. You feel like, no, I don't want to become Prime Minister. I want to become Chief Minister of Andhra Pradesh. See page 15. Very easy to say no. Okay, page 15. Unfortunate that petition is pending for 5 years. You don't know the prayer made. Read it aloud.
My lord, it is therefore prayed that Honorable Court may be pleased to issue a writ order on direction more particularly one in the nature of the writ mandamus declaring the action of the respondent number 3 issuing impugned notice dated so and so is illegal, invalid, void ab initio and without any force of law.
So if you are not challenging the notice dated 18/3/2017, 1 minute, 18/3/2017, that why have you sought this relief? You said that you are not challenging. And how, please tell us, how a writ of mandamus, in the garb of writ of mandamus, how can we issue a declaration? You have said, no, see, declaring the action. When does a writ of mandamus lie? Please tell us.
My lord, can I just show that letter?
No. Please tell us when a writ of mandamus lies.
The authority to take some action.
If there is a statutory right and there is a statutory duty.
That is the statutory duty. What has happened, my lord?
Mr.
Can I just, my lord?
No, we will dismiss your petition if you don't answer and get agitated.
No, I have not.
This is, Mister, you are seeking a writ of mandamus for declaring the action. We are asking how mandamus declare the action can be declared. Read it again.
My lord, my lord, I am saying any other rate appropriated. My lord, can I just 1 minute if my lord.
So you agree that this action cannot be declared?
My lord, what has happened?
What is happened? Prayer clause, Mister. Please explain again read the prayer clause one by one slowly.
It says.
Read. Page 15.
Yes, my lord, says that the nature of writ of mandamus.
No. It is therefore prayed.
It is therefore prayed that this honorable court may be pleased to issue writ, order or direction, more particularly in one in the nature of writ of mandamus.
Declaring.
Yes.
Can the writ of mandamus be issued for declaring the action?
My lord,
This is the query.
My lord, the further line is there.
No. We first answer this, then we proceed
My lord,
further.
what I'm saying, what has happened.
It requires an interpretation, right? So read it first fully.
My lord,
Fine.
my lord, I'll just take 2 minutes and then I think, my lord, I'm unable to reach to my lord. I'm not asking under writ of mandamus that the direction given to take over my asset. I'm not challenging that, my lord, in this case. What has happened?
Then why have you read that? Amend the prayer clause.
My lord, may see this.
Right, prayer, amend the prayer clause if you are not challenging. Amend the prayer clause if you are not challenging.
Can I just, my lord, just 1 minute, if I have come from Mumbai just to assist my lord, if can be given 1 minute time, only 1 minute.
No, you can have 10 minutes. There's no problem, but see, you have to answer the query. You first read the prayer clause.
Yeah,
then.
I read full minute.
And
Yes.
what according to you it means.
Yes, and
No, read fully. It is therefore.
it is therefore prayed that that this honorable court may be pleased to issue a writ, order or direction, more particularly one of the nature of writ of mandamus declaring the action of the respondent number 3 issuing informed notice dated so and so is illegal, invalid, void of nature and without any force of law, and consequently direct the respondent number 3 to hand over the possession of the properties as per the direction of respondent number 2. My lord, respondent number 3 is not accepting the direction of the respondent number 2, the SDM.
1 minute. 1 minute. So now you are saying this after reading the prayer clause, you are saying that you are not challenging the order dated 18/3/17. Correct?
Lord, this is not the order. What has happened if my lord may see for a minute if that letter.
No, mister.
This letter says I
You
will
are-
take possession.
Declare the action of impugn notice illegal, invalid, void in ab initio. So you are saying that we are not challenging that.
My lord, what has happened? The DM has said to Tehsildar, respondent number 2 has said to Tehsildar, please take possession under section 14. Can I just read?
Yes, please.
My lord, what has happened? I am a lender, my lord. I have filed section 14. Honorable DM has said, Sildar, you take the possession of this property and hand it over to, I have brought 4 judgments to the Edelweiss Asset Reconstruction Company, which is the petitioner hearing. In this letter, Tahsildar is saying, I will not do this. That is his case. That's why we have come before your lordships.
Surface Act.
My lord, I have a
Surface. Yes.
My lord,
So what is, so again, we are entitled to ask you question and you are entitled to answer it without getting agitated, right? It's not that we are not hearing you. This you are seeking this declaration illegal, void ab initio. You are saying that you are not challenging this, right? Shall we record it?
No, my lord. I'm saying, my lord, DM has passed an order to respondent number
I think
3.
that order, according to you, should be implemented in the rate petition under Article 226.
Yes,
Fine.
well, that is, in my lord, may see section 14 what it says. And the judgment says what is to be done. My lord, I will read section 14 for a minute, my lord. I think I could not make myself clear. I am extremely sorry, my lord.
No.
I'm not educated by Robert of-
No. You are very expert in trying to avoid inconvenient answer. You should have said, first thing we would have appreciated if you have said, sir, prayer in the writ petition is not properly drafted.
My lord, I'm
Properly drafted, we would have appreciated. You are trying to cover us by interrupting in between and not admitting that it is not correctly drafted. This is what it is, mister. We understand everything.
I'm extremely sorry.
And you are trying to tell us I have come from Bombay. So what does it
I'm requesting.
doesn't matter? Yes.
Can I read, my lord? Should I read section 14?
Then what do we do with your prayer clause? First of all, you tell us.
In the second part of the prayer,
You are relying on the now emphasizing on the second part. First part given. You only want that respondent number 3 to hand over possession as per direction of respondent number 2.
if that happens, I am satisfied, my lord. My
No. There is no question of
my
satisfaction.
lord, it is the prayer. It is what, my lord.
We will say that after going through the prayer, you said that this is the prayer.
My lord, these are the 2 prayers, my lord. what is there, my lord, if the both prayers are interlinked, my lord, what has happened? Respondent number 2 said to
So
respond.
we are, Mr. That's what we are asking you, that you are challenging this order dated 18/3. You should have said yes.
My lord, simple. He has refused to pass the action. He has respondent number.
So you are challenging the order, no? You are entitled to challenge.
Yes, my lord, it's a notice.
You should, you are challenging, so you should simply say order is in two parts. First, I challenge the order, it is not properly worded, but I challenge the notice dated 18/3/2017. And secondly, I want a direction to respondent number 3, Sealdar, to hand over possession.
Yes, my lord, this is the only thing, my lord. Nothing, this is the only short relief.
This is not what you are saying. You are.
Yes, my lord. Actually, we produce all the seal certificate, everything, around 2000 page documents we produce, my lord, to the last submission after the observation of the court, your lordships. All the sale deeds, everything we have submitted.
So you say that the Chief Metropolitan Magistrate has no jurisdiction to implement its own order, right? So, and that for that High Court is required, and 226 you can file.
Actually, he has not done. My lord may see that letter. It is at page number 17.
Yes. Anything else?
Let's have that. There is an order passed by the Honorable DM. That is at page number, your lordship.
Again, DM, CM, PM.
District Magistrate, I'm sorry. District Collector has passed dated 9/3/2016 to take the possession and give it to us. That is at page number, your lordship. 3/9/2016, your lordship. That is at page number 49 to 56.
All right.
My lord may see at page number 55, the effective part is there. That these properties should be taken over by the Tehsildar and handed over to the authorized officer of the ERC, Authorized Asset Construction Company. So, sir, thereafter, the Tehsildar issued a notice that I will not do it. And that's why we have come before your lordship that it should be given to under section 14. Because we are the person who these properties were mortgaged to us, and mortgage is upheld by the district magistrate when we filed petition under section 14. And your lordship, in several matters, petitions, if my lord, I can file all the judgments. My lord will say, then I can make a compilation, otherwise I can give one by one. I have judgments, can I pass on?
Why not?
Yes, sir.
Which judgment?
It's a judgment, it's judgment of Bombay High Court, which refers to Supreme Court judgment.
Supreme Court, you should tell.
Yes, Supreme Court.
Bombay High Court will have persuasive value. It's not binding precedent. As you are citing, that shows your precedence, right? If Supreme Court first, which binds us under Article 141.
In Supreme Court, also this is mentioned, the Supreme Court judgment is mentioned in this order.
The choice is yours, Mr. To rely on. We can't tell you how to argue a case. Choice is yours. Your clients have engaged you.
Your lordship.
Fine. Which paragraph?
Page number 18.
What are the facts?
Fact is that how section 14 has to be implemented. Right. And that is at page number 18 onwards, I would like to show your lordships. Page number 18 onwards. And so all these things is in affirmative, and then only I want to show page number 19, your lordships. Asset Recovery Corporation Limited. This is the judgment passed by Supreme Court. It is reproduced. The
the judgment. Where? What is the citation?
This judgment, Supreme Court judgment, your lordship. That I do not have. I will file then by your lordship.
No. Not after having argued. Yes. Yes. What else?
Your lordship, I am come here to that order of the DM should be implemented. That's all. That's my only submission, your lordship. Because section 14.
No, so the proposition you are relying upon is that the district magistrate passes in under section 14, the SARFAESI Act, and High Court is the executing court in respect of DM, according to you.
Your lord,
Fine.
if lordship.
He has no power to execute his order, and we have to do it in under article.
I have written to letter, that letter also I filed affidavit before your lordships. That is affidavit is there on the court. We have written to them, that affidavit is.
We have got it. We have relied on this. You have relied on this.
That's my, only one section I want to show, section 34 of the SARFAESI Act.
Yes.
Which says civil courts jurisdictions are barred. So I have no other option than to come before my lords. Because section 34 says civil court jurisdictions are barred. And I am before your lordship if DM has passed an order and Tahsildar is not implementing. That's why I am before your lordship. I have no other option to go to any other order, your lordship.
Fine.
That is my submission.
Yes. Mark the present. What's your name?
Rajiv Kumar Pandey. I have appeared at the admission stage.
No. You have appeared before us for the first time, therefore we are asking your name.
Yes, I have given.
Heard on the question of admission. The petitioner is an asset reconstruction company. Full stop. An order dated 3/9/2000 In the beginning, you write heard on the, yes. Next, 14.
Requesting to pass over, my lords, council is on his legs in the NCLT.
Amendment have you filed?
I'm not aware, my lords, the council has requested me to ask for a pass.
All right, pass through. We don't know when it will come. It can come immediately also. Yes. Next, 15. Under 40. Yes. Yes.
Lordship, in this case, madam, the petition is a gazetted rate master grade 2, madam.
We have passed similar orders in.
No, study, lordship.
Admitted for
319.
hearing. Heard on the question of admission, petition is admitted. You want an interim order permitting you to participate in the counseling and grant you 10 marks and transfer you to Hyderabad. We know that.
Not Hyderabad, madam, because Hyderabad government teachers are there, madam, here, local, but nearby
You are,
government.
1 minute. You are challenging the validity of Rule 6 to C, right?
Yes, madam, because.
Is the order passed by us? Please see, this order binds us. It may be wrong also, but you will have to go to Supreme Court too.
One submission, madam. He is a gazetted master is a multi-zonal post, madam. For the, he will be transferred to, other zones, madam. Here the denial of the 10 points, madam, on the ground that the spouse is working in Hyderabad district. That is only the ground, madam. The petition is working in Medchal Malkajgiri district, madam. So, madam, any nearby place, he can opt, madam, if 10 entitlement points is given, madam. It's a
They are admitting the petition, asking them, and you want us to grant 10 additional points by way of an interim order.
Suppose, because of spouse working in Hyderabad city, madam. So, spouse points, entitlement points, I am asking. Because it's a multi-zonal post, madam, he will go far away place, madam. So, any possible, if he is allowed 10 points, he will be nearby, reasonable nearby place, madam. That is my contention. It is not a district post, madam. I am asking only for 10 points, entitlement points on spouse ground. Spouse is working in Hyderabad.
15, 16, 17, heard on the question of admission. Petition is admitted for hearing. Rule nice, I call for, don't call for records. Rule nice, I will stop. Notice in returnable in 4 weeks. Learned special government pleader grace warrant is granted. You don't say. the orders are being typed. This order, yes, give this order. How it is being typed. Liable to be, so reliable to be. Of what? Huh? So long as room stands, thereafter nothing. Please do not do it. You are an experienced person. If you have any this thing, please ask any confusion. You give that this thing. That
Please, Your Lordship.
take one more printout of this. One more printout and give it to me. Yes. 18.
Please, Your Lordship.
Yes.
My Lord, the matter is under SARFAESI Act. The petitioner already exhausted the remedy before the DRT.
And 18.
My Lord, I mean, he did not go before the DRAT. He lost before the DRT, while the present writ petition against the judgment
He
of the
should
DRT.
go to DR.
No, only one submission, my Lord, subject to Lordship's kind consideration. My Lord, matter was admitted in 2016 and status quo has been ordered by this Honorable Court. For the last 6 years, my Lord, the matter is pending.
We will continue the stay for 6 weeks till you file an appeal. We will direct appellate tribunal to treat your appeal within limitation.
That's my Lord, I mean, I'm grateful to Lordship. Only one, my endeavor is, but normally, my Lord, when the matter is pending for a considerable period of time before the court, and also having stay orders, my Lord, I mean, your Lordship will not be relegating the parties to the alternative remedy.
That is another this thing, but there are both the cases, or you will, as a senior counsel, you will appreciate there are some cases where the court will say that once petition is admitted at the time of final hearing alternative remedy, the court, the party shall not be relegated, but at the same time, there are cases which say that the still, I mean, admission doesn't mean that the right of the court is, because see, the judge bench decision of Supreme Court was not taken into account by a division bench while entertaining the writ petition.
And
therefore, we don't want to say it's in curiam, but it is so. You will appreciate that you don't want us to go to the extent of saying that the order is ignorance of law laid down by binding precedent of Supreme Court.
Yes, my Lord, I mean, just one more submission and leave it to Lordship. My Lord, the issue arises is only a pure legal issue and only 1 minute, my Lord, it may take. If your Lordship, my Lord, I mean, permits me. If your Lordship, my Lord,
Oh, Mr. Senior, in every case we are taking this view. Day in and day out.
I'm saying it, my Lord. I mean, I'm saying that the Honorable Court is sitting on Sachavati Tandon, my Lord, the Honorable Court is
and there's
relegating the parties.
So we have to be consistently wrong.
Yes. No, only difference is, my Lord, I exhausted.
Lighter way. We have to be consistently wrong.
Only difference is, my Lord, I exhausted one remedy. Only thing is, appellate remedy I did not exhaust. My Lord, the point, I mean, if I am permitted to submit is like this. Petitioner is a borrower, my Lord, I mean, who is defaulted. My Lord, bank conducted an auction in the month of March 2017, I'm sorry. And my Lord, as per the rules 9(4) of the security interest rules, 25% will have to be paid by the bidder at the time of the auction, and balance 75% will have to be paid within 15 days. If it doesn't pay the balance 75% within 15 days, my Lord, the auction collapses unless there is a agreement between the bank and the bidder extending the time beyond the 15 days. In this case, my Lord, he paid the 25% on the date of auction in the month of March 2017. Remaining amount he has to pay by the middle of April. He did not pay. On 17th of May 2017, my Lord, I mean, mortgaging the very same property, the bidder has availed loan from the very same bank and paid it as the balance sale consideration of 75%. And the bank then gave sale confirmation in his favor. And my Lord, that has accordingly, my Lord, the transaction has been concluded. Bank giving loan against the very same property to the bidder. My Lord, unless the sale certificate is given, bidder will not become owner of the property and he cannot mortgage the property. Bank on the same day gives a loan to him, and my Lord, I mean, gives a sale certificate to him. Beyond all these things happen beyond 15 days. There is no agreement between, my Lord, extending the time between the banker and the auction bidder. So, my Lord, these are all the infirmities which the tribunal, my Lord, did not properly go through. And my Lord, I mean, unfortunately, has drawn wrong conclusions. And my Lord, rendered the judgment. So, my Lord, my humble submission, Lordship, please, my Lord, if your Lordship considers, I'll take your Lordship through the order of the tribunal. I request, my Lord, the tribunal order, page 20 may kindly be seen. paragraph 16 of the order of the tribunal. I may make it clear, my lord, the order of the tribunal I'm reading. Appellants are
Yes, please.
Yes. Page 20, my lord, I'm reading.
Yes.
Yes. I may make it clear that the applicants are not questioning the possession notice, sale notice, auction notice held on so and so and confirmation sale 28/3/2017. What is questioned in this securities application is sale certificate dated 17/2017. Main ground for questioning sale certificate is that the applicants have not been provided reasonable opportunity so and so so and so. Then my lord, section 13(8) is extracted, that's not necessary. Then I request your lordship to kindly turn to next page, page 21, paragraph 19. The other contention advance is bank facilitated option purchaser by granting a loan of 16 lakhs as on the to enable them to deposit 75% of the purchase amount. Applicants did not bring it to my notice that any provisions of the Act which debars the bank in sanctioning credit facility to the purchasers. Therefore, I do not see any flaw in the option of the bank. Next para. Applicant counsel contends that the respondent bank purposefully delayed confirming sale held on 22/8/2016, so and so, so and so. That's also not relevant. Lord, the dates are relevant. I bring to lordship's kind notice. The auction took place in the month of March. In the month of March, 2017. Sorry. 28 March 2017. Auction took place. He has to deposit 75% within 15 days. He did not deposit. On 17/5/2017, bank lent him amount against the very same property which was subject matter of auction, and that very same amount, my lord, he has paid towards the balance 75% amount, and then bank, my lord, confirmed the sale certificate in his favor. This is totally illegal. The rule says like this. Rule 9(4) of the security interest rules. Yes, I'm sorry. Rule 9(4) reads like this. Balance amount of purchase price payable shall be paid by the purchaser to the authorized officer on or before the 15th day of confirmation of sale of the immovable property or such extended period as may be agreed upon in writing between the purchaser and the secured creditors, in any case not exceeding 3 months. My lord, neither in the DRT nor in the counterpart before this honorable court, the bank did not say, my lord, there was a agreement between both the parties, that is the banker and the purchaser, to extend the time beyond 15 days, and accordingly, my lord, the confirmation given on 17/5/2017 is valid. They said that, my lord, I mean, I would not have any argument at all. They did not say that. But, my lord, I mean, in the absence of any agreement between the purchaser and the bank to extend the time period beyond 15 days, my lord, on the 15th day, my lord, the option collapses. And the amount already paid by him, 25%, my lord, stands forfeited in favor of the bank. It did not happen. But after 2 months, my lord, the bank has issued the sale confirmation letter in favor of the option purchaser, by giving a loan on that day to himself, my lord, appropriating that loan towards the 75% amount. This is the infirmity in the option, which, my lord, the tribunal did not appreciate. That's the only point. If your lordship, my lord, still considers, I'll go before the appellate tribunal. Your lordship may kindly extend the stay for a period of 30 days. I'll, my lord, avail the opportunity. Yes.
So you have finished the argument. Let me share with you this thing. We had a chief justice in our Madhya Pradesh High Court.
Yes.
And he had this rule of, he used to rely on, you must have read 73 Supreme Court, page 1 and the last page, that the jurisdiction of the court under Article 227 can be invoked only if the order is without jurisdiction. So in Madhya Pradesh High Court, the writ petitions used to go before division bench like 227. So his court master would tell before the case is called out, he would say petition under Article 227. So he had prepared a pro forma sort of an order, like 2 paragraphs. So he used to, as soon as the council would stood up, he would say dismissed. So one council insisted that it's my case, I have a right to argue. So he said, yes, of course you have. Please go ahead. He relaxed in his chair, the division bench. And then after senior council concluded, he said order stands. Lighter weight. Mark the presence in this petition. Yes, mark the presence. With consent of the parties, matter is heard finally. Yes, you can challenge it, right, in SLP. Yes. Yes.
Millard, I am for the auction purchaser, Millard. I am respondent number 5 and 6, Millard. Kindly record my presence also.
It has been marked, mister. We don't know.
Item 19, my lord, I'm requesting 3 weeks time, my lord, to file. Item 19, my lord, counter has to be filed.
Mister, this is like this, the order will lose its efficacy, right, after 3 months. And on the basis of unregistered documents, you are meeting this thing.
That's a what?
The registering the documents, right?
My colleague.
Mister, it's serious issue. Serious issue, Mr. Narendra Prasad, which requires immediate attention. I don't know, we don't know why have you issued this GOMS.
That's
Unregistered documents for attestation of notary.
Consider
Right, like how this can be, this is straightway no counter. This is contrary to statutory provision contained in Transfer of Property Act. How can you possibly defend this order? We don't know.
Week's time, my lord, because my colleague friend GP is not there. Some personal inconvenience, my lord. 1 week, because last time I.
21st September. 21st September. Mr. Harinder Prasad prays for and is granted a week's time to enable him by way of same order which was passed in item 2, appeal under section 18 of the SURFACE Act, right? Alternative efficacious remedy, para 5 and 6 of that order, Satyavati Tandon. In this petition, right down, in this writ petition, the petitioner has challenged the validity of the order dated 26/9/2022 passed by the Debt Recovery Tribunal, right? Then that para 5. None for the petitioner even when matters called in second.
For the petitioner, your lordship, in this
Ah.
number 14, your lordship, online
Ah.
permitted to.
Yes. What, have you filed amendment? Mister, have you filed amendment?
Yes, your lordship. I filed.
Appeal allowed. Mr. Raju, Learned Counsel appeared through video conferencing, heard on IEA number so and so, and application seeking amendment. For the reasons assigned in the application duly supported by an affidavit, same is allowed. Let amendment be incorporated in the writ petition within 3 days, list thereafter.
My humble submission, one request, your lordship. Auction may.
3 of 23. You argue on this thing, what, right now, if you, but you are, incorporate amendment. No,
Auction is confirmed party.
No, nothing.
Kindly consider.
We are ready to hear you on this thing, but please incorporate the amendment.
Your lordship, I can do it. Kindly have it tomorrow. Your lordship.
All right, Learned Counsel for the petitioner undertakes to incorporate the amendment during the course of the day. List on Monday, Tuesday, 19/9/2023. Yes.
If you guys.
Yes. Yes.
In the lead matter, your lordship's item number 20, Ms. Brenda Grover is appearing online.
Yes.
My lords,
This is this is for final hearing or what?
my lords, this matter is to be heard. It was actually heard by this honorable court earlier also.
Yes.
Extensively, but we will have to start afresh again. If I can.
So no, one thing only, madam, this is for final hearing. So pleadings we believe are complete or not complete?
Not completed, your lordship.
None of the parties have filed counters still.
Then why are you not filing? You don't want to file.
As far as I am
She
concerned,
is ready to argue the case. You don't want to file counter in.
state has not filed counter. As far as we are concerned,
Mr. Prasad, what is this?
Our applications for
4
implementation
years have
might
passed
be ordered,
and
your
it is
lordship.
coming up for hearing. You are not.
Some implead applications are also.
No, that implead application bench has entertained and taken note of submission sort of. That is kept pending. We can hear them. There's no problem. What about counter? How can we hear without counter? That means whatever she says has to be accepted.
I am requesting.
That's the Supreme Court decisions that whatever she says, whatever she has said in the petition.
4 weeks, Your Honor.
What 4 weeks?
But,
This is Mr. 4 years.
But 4 weeks and consider.
Yes, madam.
Fix it.
My lords, may I just mention the state?
Yes.
The state has, for reasons best known to the state, neither filed a counter, nor has their counsel ever agreed to argue. The entire order sheet of this court will repeat.
No, we assure you, madam, that now we will make Mr. Prasad argue the matter. If formally time has not been granted, we have to grant them, right?
Please, my lords,
Shall we fix some date in October, madam?
Very grateful. I would be very.
Which date you tell us?
My
Any
lord,
date in October?
would 6th of October suit my lords? If it is convenient, my lords can then slot some time so that I can at least open the case and take my lords through the matters and.
Yes, of course. Mr.
6th is a Friday.
Madam, 6th happens to be a Friday. The bench normally would be till 1:30. So can you suggest anything 9th or 10th October?
9th of October.
9th October is okay. Yes, Monday.
Will my lords schedule a time?
Yes. You please mention on that day. We are granting you liberty to mention.
I'm very grateful.
Yes, you can mention if it is finished. We are able to finish. Otherwise, at 2:30, you please mention. We will take it up on 9th.
I'm very grateful, my lords.
9th of October. Mr. Whosoever who application for implement are pending. So, Mr. Harinder Prasad and who else, Mr. Respondents?
Your lordships, my applications for implement also are.
It will be considered on 9th October. Presently, only we are asking which other respondents want to file their counter.
My lord, R5, my lord,
Yes, Mr.
item 24, R5, I appear, my lord, we will file a counter.
All right, you have filed or you will file? Mr. Harinder Prasad as well as Mr. Raghuram, learned senior counsel for respondents, pray for and are granted 4 weeks time to file counter. List on 9th of October 2023. Please, Mr. This is 4-year-old matter. Please do it on a priority basis.
I'm grateful, my lords.
Yes, Mr. Raghuram, please file. On our date of hearing, 9th October it shall come up. Yes.
We'll be ready.
Your Lordship, item number 26 also not filed any counter. Your Lordship.
They will file. Whosoever, Mr. Prasad, all cases we are granting you, it's a common order.
Yes.
At a common order in all cases, 4 weeks time to Mr. Prasad, Mr. Raghuram and Mr. Harinder Prasad. Please file counter. Yes.
This matter, my lord, yesterday your lordships have said it will be taken up tomorrow, my lord, continue in the list. We'll give the note to.
Yes. You are appearing as amicus.
Even in 20th item, my lord, I'm amicus again. But my lord, I would like to argue, my lord, after everybody argues the matter, my lord, I'll assist the court, my lord.
Which is 27?
20th item also, which has been adjourned to 9th.
It is adjourned.
Adjourned to 9th. I am there, my lord, as an amicus. So
We will hear you.
I'd like to argue, my lord, after everybody argues the matter.
All right. Yes. No, we thought that in some other case you were amicus also. Yesterday you from here you appeared.
Now, presently it is next. Yesterday's matter has been called.
Yes.
I mean, both the matters.
Yes. 27, please.
Tomorrow, my lord, we'll give the note. Yesterday, your lordships have said it will be continued in the list.
Continue, or taken up tomorrow, correct, yes. 28 matters. Then don't call 27, it will be in the list, 28.
Yes,
Please, your lordship.
Yes.
But this is in the same writ appeal yesterday. my lord.
Yes, madam.
These two writ petitions, the
Some, our staff has taken dictation yesterday in a writ appeal. And I had requested her to give a printout. Has she given? What's her name? Who had taken, he was arguing senior counsel. Huh? No. This senior counsel was standing behind her. He argued yesterday one matter, no? Who was the stenographer?
as these two writ petitions are concerned. My lord, the order under challenge is akin to the order challenged in that writ petition against which an intra-court appeal has been filed. That is 16(2). The joint collector order is same. These two petitioners who are there before my lords were also the petitioner before the Honorable High Court in the earlier round of litigation, in which the learned judge has granted certain directions. Those directions have not been complied with. My humble submission was it is sheer non-application of mine. But I also brought to your lordship's notice so far as
1 minute, one. You are addressing us in 17192, right?
17192, Milord, so far as the other writ petition is concerned, Milord, it is also similar. There, the name of the petitioner is Shyam Rao. Here it is Kesav Reddy's wife, Milord, who consequent to the demise of Kesav Reddy has.
So his name was also there, no?
Yes.
Kesav Reddy's name is also there in that Tehsildar thing.
Yes. Oh, Milord, yesterday my learned friend.
She said
Milord was submitting that my clients are not in possession. Milord, I compiled a book of all the papers together for the Honorable Court's convenience and categorized them into two categories. One is documents evidencing allotment. The other is documents evidencing possession.
Yes, madam. Why?
The Honorable Court so
1 minute.
feels, I can pass on.
Why do you say the case is different than the one we decided yesterday? Because the name of her husband, widow, the petitioner also appears in the list of Tehsildar.
No, my lord, it is not the list of.
Which is the?
The notification.
So yesterday we saw which page?
No, my lord, 51079 notice.
But I just submit.
Not this.
Madam, you have to be fair, right? Like this thing, if it's there, it's there. You can't help. You have already taken a view. Way is northward.
This person's name is not.
Not there, Keshav Reddy. Where, yes, Mr.
Page 61 of writ petition 25672, your lordship.
Yes, madam, 25672. I think he showed us yesterday.
Shyam Rao's name I'm sure.
No, Keshav Reddy.
Kesav Reddy's, that's the reason I compiled a book, my lord.
No, is it there or not
It is
there?
there, according to me, it is there.
Which serial number? Which serial number?
Original papers. Original papers. Original paper.
Nokudu is there and Keshav Reddy, which serial number?
This
What's happened?
page 61. Shyam Rao. Lord, may I request the Honorable Court to peruse it, papers and 25672.
Something has to be added in one para. I will give you dictation. To whatever, the break. I will send for you.
Serial number 287 is Shyam Rao.
No, this Keshav, we are dealing with Keshav Reddy. No, so 1 minute. We will leave aside this Keshav Reddy for a while. Shyam Rao is squarely covered, right?
287, yes.
Madam,
My lord, I.
25672. His name appears at 287. So Shyam Rao is covered.
Just 1 minute,
Huh?
1 moment.
Huh.
My lord, this is with relate to survey number 1007. The survey number 1007.
Give us 5 minutes.
They don't take me. Pages basically. Don't have this one page, the list.
Yes.
Yes.
My lord, I have a missing page.
Convenience. Lord, I have
No,
prepared.
no, no. See, Mr. We are going by yesterday's order.
Yes, yes.
We are not recording a finding here with reference to these documents which you are producing, then she has to be given time, then these paper books she can't see.
These documents are nothing but the documents forming part of the record in the writ petitions. I have separately culled out the documents evidencing allotment,
No,
evidencing
but
possession.
see, Mr. We will go to this thing, your name then does not appear in the list, right?
It does.
Then why are you then giving?
Yes. If your lordships are.
Then it is covered, no, Mr. Simple is yesterday, it is covered by yesterday's order.
It is,
Madam,
my
correct?
lord, it is covered by yesterday's order. One page is not there with me. That's why I could not find. There are some.
No, this is Shyam Rao's serial number
I've
287.
seen in the seniors
Right?
document.
So WP 5672, same order?
Yes.
Huh? Yes. One minute. The petitioner, this WP number
Tuesday, Your Honor.
But we are, this, item 30 we can hear, no, senior counsel?
Yes.
In the break, after the break, we will hear.
My request, my lord, would be considered, my lord, to have it on Tuesday. Item 28, Tuesday, Your Honor.
28,
Tuesday, Your Honor.
not Tuesday, we don't know. Next week it will come up.
Very well.
Learned senior counsel for the item 28 petitioner place for adjournment. List next week,
Very
28. And this 30 will continue. We will take up item 30 after the break. list.
He has chosen for the counseling provide a first notification, my lord, which is in page number 129 to 33. Wherein, my lord, after issuance of that notification, a fresh notification which is under challenge has been issued by the respondent authorities for the purpose of applying for the new candidatures even, who have not even applied for the first notification, my lord. What happens is that, my lord, in the first notification is itself, there is a.
You are challenging 11/9/2023.
My lord, the ground is that, my lord, there is a clause number 5, my lord, in the notes of the first notification.
What is 11/9/23? Which page?
25/8/2023, 123 to
No,
130.
11/9/23, which is under challenge in this petition.
Yes, ma'am.
175. Oh, you know better about his case. Applications are invited. What is your
Maybe.
case?
In the abstract of that notification, my lord, the first para, my lord, if it may please to, may I read, my lord? In continuation of this notification dated 3/8.
No, where? 175,
173.
170.
173, page number 173.
Starts.
It starts from 173. 173, my lord.
What ground, Mr. Rao, he has challenged? He is unable to tell us what ground. We can hear him, but what ground it is been challenged? 11/9. Petitioner has already taken admission. Where? Huh? No. So he has already been allotted admission. Then seat. Then why?
According to, if a fresh registration is permitted, the candidates having more meritorious may take better seat in a better college.
Without affecting him.
Without affecting him.
Oh, he has already taken admission.
He has already taken admission, Milord, in Mamata Academy of Medical Sciences, Bajpalli, where the last rank.
The Academy of Medic.
With all due respect, my lord, I have not taken.
You are unable to tell us. That's why we will hear you. It's not that we will not hear.
One correction, my lord.
1 minute.
If fresh registry
If he's saying incorrect things, you can point out. You did not tell us. So therefore we had to ask. You are just reading. You did not know what page. So we are asking you.
If fresh registry is permitted, more meritorious than the petitioner, if they missed it in the first notification. If you register again, in the second phase of counseling, he may not get better college. That is his allegation.
No, but he can't appear in second round, right?
He can appear second round of counseling. Having appeared first phase of counseling, got a seat, he can also appear for second phase of counseling.
He has participated in the first round of counseling.
Yes, sir.
And has been
given a seat.
He has been admitted.
Yes. But if he is not admitted, Lord, he will not be permitted.
Permitted to participate in the second round. Which is that rule?
Rule 1, GYMS number 126.
You have that copy. We have this thing. We have passed an order. GOMS. Yes.
My lord, the facts of the case is like this, my lord. He got the provisional final list. After that, my lord, he has applied.
First phase of counseling, you appeared.
I have appeared, my lord.
When were you allotted a seat?
I was not chosen for the third category, my lord.
No.
I was getting.
Mr. On facts, you have to be clear. Were you allotted a seat in first round of counseling?
Not allotted, my lord.
Not allotted.
Because
this is all incorrect, right? Medical. Acha. So then.
I have chosen for the first college, my lord, first category college. That is Apollo, my lord. Wherein my merit comes under the category 3. Because I am getting the category 3, I have not chosen for the very same.
So what is category 1, 2 and 3?
Category 1 is Apollo College, my lord, and second is the another college, my lord. Is the
priority of colleges.
Priority of institution.
Priority of institution. At the first tense, my lord, I have prioritized for the first college. And after that, my lord,
You have not been allotted any
Not
seat
been
anywhere,
allotted.
anywhere.
anywhere, my lord.
Okay. Then why are you challenging this?
What happens?
11-9, you should appear. Then only you will get a seat. Instead of appearing in 11-9, you are challenging it. Supposing if the petition is allowed, what happens? You have not been allotted any seat. This round of counseling pursuant to notification will not take place. What will happen to you?
What happens is that, my lord, I am into the game with certain rules, my lord, which is in point number 5, my lord, wherein it has stated that. Kindly see the point number 5, my lord.
He is unable to comprehend this council.
Are you agreed with the notification, subsequent notification?
Subsequent notification.
Why?
Why? Because, my lord, the new candidates are also getting the opportunity. Because of that, my rank would be affected, and who are already been gone through the procedure, my lord, they are being affected because of the new candidates who are not applied for the previous notification. What happens is that, my lord,
You could virtually amount that you're preempting the other candidates who are also aspirants like you. See, subsequent notification is given for some purpose.
because in the first notification, it bars the new.
Many seats to be filled up in subsequent. He wants admission against all the seats. He alone should be admitted.
Lakshmi kindly see.
Nobody else.
Then Lakshmi kindly see page 3. His rank is 1,77,747 lakhs.
1,77,000.
747.
We have, Mr. Frankly speaking, was speaking for myself, Mr. Rao. I have not been able to understand. He has not told us why is he challenging. We unable to understand.
Page number 1.
At least tell us what is petitioner's case so that we can.
But he has given page 3, he has given your last.
No, he said that he has not been given any seat anywhere. Number 1. Now he is challenging 11-9-23.
Reason is, Millard.
What ground?
His apprehension is, Millard, if a pursuant to the second notification, more meritorious candidates than the petitioner may register in such event, if they exercise web options, he may not get a seat. That is his case. That you want a.
So this thing, see, anybody can apply who is eligible.
Yes.
How can we prevent? How can we prevent anybody from participating in the notification? What ground?
He rank on.
Mr. Rao, what ground he is seeking that nobody should be permitted to participate except me?
He is anticipating that he may not get a seat.
The writ petition cannot be based on apprehension.
Yes, sir.
There has to be a legal injury. Apprehension cannot be, and apart from apprehension, there has to be a legal right. What is the legal right that he alone will participate and nobody else will participate? Which rule? Please tell us.
Yes,
I mean, he is unable, he is a young person, unable to understand himself, he cannot argue.
Absolutely, Millard. There is no legal ground to
Misconceived, right?
challenge.
Prima facie appears to be misconceived petition subject to, yes.
Page number 130.
No, Mr. What is the legal right that you alone will apply and nobody else can apply?
Page number
Which
131.
rule?
For a moment, page number 131.
130, which rule?
131.
Which rule?
Para number 5. Page number 131, madam.
This is what rule?
May I please to read?
Huh?
Candidates in the provision.
What is this, Mr.? See, first of all, you tell us what is it? Just reading something from somewhere.
It bars the new candidates, my lord, for applying in the previous notification. And in contradiction with this provision, my lord, they have issued the new notification.
No, we are only asking what is it you are reading. You are under an obligation to tell us, not read from one paragraph from somewhere. What is it you are reading?
Point number 5, my lord. It bars.
We are not very clear. We are not clear to you. Mister, please tell us.
Notification, my lord. Para 5 of the notification. Important instructions to the candidates.
What is it, Mr. Counsel? Please help us, amicus. You stand here and help us in understanding his case.
Not that. At 129, it is a notification, my lord.
Huh?
He is reading para 5 from the notification.
What notification dated?
Notification for exercising web options for first phase of counseling.
25/8, 2023.
Notification issued on 25/8.
25/8, 2023, that is the first.
He is
notice.
reading from
Yes,
that.
yes, yes.
Ah. So what is 25/8/23? Which para he is reading, Mr.?
Page 131, my lord, important.
Page 131. Important instructions. All right. What is, which instruction is it?
5, my lord.
5.
The candidate in the provisional merit list are informed that they do not exercise web options first phase of counseling. They are not eligible to exercise web options in substitute. That is the rule.
So which candidate is being this thing allowed to this thing appear who has not exercised in web option?
So I have exercised in the first web option, my lord. And the new notification is giving opportunities for the candidature who have not exercised in the first option as well. That is my grievance, my lord. If that happens, my lord, my rank would be increased, my lord.
You should have got 1,77,000. You should have got 2,57,000, and you should have said that I be. What is this, Mr. Frivolous sort of thing? Either you don't understand or what is it? Thoroughly misconceived petition. See, supposing if after first round of counseling, Mr., if the seats are vacant, are they not entitled to fill up? Are they not, should they keep the seats vacant?
My lord, for the vacant seats, if they are giving the notification, that is different issue, my lord. The seats were
this
not
is the issue.
vacant. The seats, they are asking for the new candidates to give the new applications. That is the issue, my lord. For the incumbent seats only. Even the persons who are not in first phase are also getting the opportunity. That is the reason.
Which rule says that the first phase you alone can be this thing permitted? Which rule says that the petitioner alone can be permitted to apply and nobody else will apply? Which rule?
In the very fifth point rule.
This is all governed by 2017 rules, right?
My lord. I'm only speaking with regarding to the notification only, my lord. In the notification itself, it has stated. Because of that, I am opting for the second phase. I am seeking is that, my lord, the persons who have already applied can only seek for the second phase of counseling. The person who has not got the first phase also getting the opportunity.
Let him get, everybody should get opportunity if it is in consonance with the rules. We are asking you repeatedly, Mr. Which rule prohibits, you are not pointing out, you are reading something. Which rule prohibits?
My lord,
the candidates that they cannot appear, anybody else cannot appear?
It's not like that, my lord. No.
Not like that means you have answered the query. The petitioner is an aspirant. He has not got admission, right, Mr.
He had a chance.
You told that Nagta Academy of Medical Sciences, he says it's incorrect, I have not been given. From what basis?
He had a chance, my lord. According to me, he did not exercise web option to that college.
Because, my lord, I might get in the second category college.
Appear in second category.
That's what that might happen within the people who have already applied for the first phase. That's what my contention is that, my lord. Now it is opening the chance for all of the people who have not got the chance in another states.
Which rule prohibits this? Again, we are asking you, Mr. Third time. Now you are testing our patience. That can't be done. Like, yes, madam, the petitioner is an aspirant for admission to MBBS stroke BDS course in the state of Telangana. Paragraph. The petitioner had participated correction. Yes.
May this, my lords. My lords, if your lordships permit minutes, can I pass on the synopsis minutes in the
Okay. Fresh.
May I request the lords to take up the compilation minutes? The compilation, I have compiled all the writ petition, the counters and the documents and the reply. It was filed on 11/11/2021. That's that.
This is done now. Great. One more copy of this. One more copy of this corrected. Yesterday's one, wait a period. Seven to 13 are the allottees, right?
Yes, madam.
You are challenging, where is the order of allotment? It is very,
That the various GOs are issued, no? Initially when the writ petition.
but you have not challenged those GOs. General prayer allotment be cancelled.
When the writ petition was filed, the allotment GOs were not available with the writ petition. Subsequently,
So should we not amend it? Declare,
to amend it.
ideally speaking.
We'll amend it.
Huh? Oh, what do you think?
So ideal minutes to amend and challenge the GOs.
Yes. Learned senior counsel for the petitioner submits.
I please, your lordship, to appear on behalf of the petitioner.
What?
But the petitioner is an association of freedom fighters. Formed in the year 1982, registered under the Societies Registration Act. But
It's this thing, see, Mister, this is allotment of houses relief, which should be, it is individual in nature. We don't know who are its member, like how many members, then you will add some 15 after, supposing if an order is passed, you will add 15 more people and say that it applies to them. Is the membership admitted?
membership is not admitted according to the GO.
Then how, what is the prayer?
To
Consider members of petitioner organization. Who are the members? Who will decide?
one submission. In fact, my lord,
It cannot be. They let your member who are there, they should come to the court and say that we are entitled to allotment to this thing. What is this association?
I only request one. In fact, my
You know, there may be, Mr. 10,000 members of your AP Freedom Fighters organization. Maybe who knows 2 lakhs, 3 lakhs, 4.5 lakhs.
filed on behalf of the organization, my lords. I only have one request. In fact, my lords,
We will not entertain this petition.
we have not.
The relief claimed is in the nature of this thing, and there is no list of nothing, members, nothing. This is indefinite group. Indefinite persons cannot be granted, the persons whose identity cannot be established cannot be granted relief under Article 226.
We make one request. In fact, we have not been able to make meaningful contact with the association for the past few years, my lords. We've sent
You cannot make, see, no, the reason you will find is not, in fact, meaningful, we have understood. He is not giving instructions, you look to, you will find the answer in the cost cycle, first page. Did you get the answer?
Yes, file. He was, yes, my lords.
85 at the time of 85.
85, my lords.
And how many years he must be? 88
The
now.
only why I said meaningful.
No.
The only
So 12, 13. 13 means,
the information.
what was 13 means, what is the age? 98. 100.
100 years old, my lords. The
100-year-old man has practices sense of detachment and has this thing is not attached to worldly affairs. So you will never get instruction, and even otherwise we are not dependent on you seeking instruction. We are owning the responsibility of passing an order in this case. No adjournment.
No, I'm taking an adjournment. I only request one thing, my lords. Just may kindly consider that the individuals may be permitted to make a presentation, my lords.
That you are always there.
Entitlement and.
No, we don't. We will not permit. You are at liberty to do so. Every individual or doing like see for sleeping at home at 11 o'clock. Do you need court's permission? No. Tell us. No. You because to rest in your own house is in accordance with law. So therefore, nobody prevents you. And you don't need court's permissions, sir. Whether in the morning at 6:30, should I brush my teeth? Give me permission, right? So we don't give permission to that. Then should I take bath daily? Should I have lunch? This all not.
But the list was not annexed, my lords. The prayer was made conscious to the condition in the GO that.
No, you understand. You understand, right? You are you intelligent person from face we can make out. You are intelligent person. You understand that we will not entertain this sort of a petition. Members of petitioner, who are the members? Nothing. The list is not enclosed. Nothing. We can't grant this sort of a relief. All right. On the question of, yes, mark the presence. What anything you want to say, please say.
My only request was that they may be.
You better
allowed to
withdraw.
make the representations in.
Withdraw the writ petition with the liberty to the members to take recourse to such remedy as may be available to them in law. That we will grant. Then you advise them when they should sleep, when they should brush their teeth, when they should have lunch. Then you advise, because it's a You are an expert. We have given up this job after accepting the assignment long back.
Like your lordship's pointed, we had seen that the petitioner, the deponent is 85 years, we are aware, conscious, my lord. It's the only request I have. My request was short passover, but I'll just
No,
take
nothing,
it
no
as
password. Nobody will give you instruction, mister. Nobody will give you instruction
senior.
for withdrawal. No, no, nothing. No, we will pass an order. We are not dependent on your withdrawal. See, the only thing is, if we say something, it will affect you. That's why we said, if you don't want to, fine, we will write. Yes. The petitioner claims to be an association of AP Freedom Fighters Organization. The (32 to 72). Oh, bunch. What is it? Teacher? Hmm. You said I will take 3 hours and we told you, right? Same case. Same case, no?
I apologize.
No, no, Mr.
Yes.
Dev, it's not with the purpose to seek an apology. We are telling,
Yes.
we are just trying to ascertain whether our memory is correct or not. Same case, right? You said, then you told us, no, no, I will do it in 20 minutes. Right? Give us 2 minutes.